Good afternoon, everybody. My name is Chada Satia. I'm the director of SBDC here at Chinese Mutual Aid. We are funded by the SBA and Illinois Department of Commerce of Economics and Opportunities. We are happy to be presenting these webinars with our attorney, Charles Wentworth. I'm going to let Charles introduce himself in a minute here. So with the SBDC, we offer no cost confidential advertising. We do anything from business plan writing, helping you get loans, marketing, sales, business plan, grow your brand, social media, selling online, anything that you can think of in terms of running a successful business, we are here to help. And everything we do here is no cost to you, as it's funded by the government, and your tax payments is paying for all these support. So keep going with introducing our presenter here, Mr. Charles Wentworth.
All right, thanks. Yeah, like I said, my name is Charles Wentworth. I'm an attorney in Glen Ellen, which is kind of right in central DuPage County. And I've been practicing in Glen Ellen since about 2010, so going on 12 years now. My partner is Rick Lofgren. He and I have been together for about 9 years, and we do all kinds of different, we work on anything that has to do with businesses, whether it's startups or purchasing a company or selling your business, writing contracts, doing leases, commercial real estate. We do anything that touches the business, and we do it both on the transactional side and on the litigation side. So if you whatever kind of small business needs you've got, we'd be happy to help out here. So let me share my screen here. So we're going to talk a little bit today about how to know what your business is and what you can do to meet some of the goals that you may have for your business. Just first thing that I want to talk about or touch base on is, let's see if I can get the slides to roll over here. There we go. All right, so just a quick disclaimer. I'm not your attorney just because you're here in the presentation. If you want me to represent you, feel free to reach out. My contact information is going to be at the end of the slideshow here, or you can get a hold of me through the SBDC. And happy to help out with you, but there's no attorney-client privilege here. You can ask questions, but my answers are going to be probably pretty general. I'll probably answer how I would, just not specific to your situation, but just generally based on what my experience is with similar kinds of situations. So, all right. So first, what's your business? A lot of business owners think that their business is what they sell. That they think it's like their product, or if they have a service or a piece of software, something like that. This actually is not your business. These things are just your deliverables. Your business is actually everything that goes around getting your deliverables to market. So that's your marketing, your accounting, any HR that you have to do if you have employees or independent contractors, and any legal issues that you bump into, whether you have to write a contract or have someone look at a lease, anything like that. Those are all, your business is everything that you have to do in order to make sure that your deliverable actually gets to market. So one of the tricks that small business owners have is trying to figure out how many of these hats do they want to wear on their own? How many of these things do they want to try to do without hiring somebody that has a little more expertise? And some of these things you can do on your own. In fact, all of these things you could probably do on your own. The trick is, do you feel confident in your ability to fulfill whatever the requirement is here by doing that by yourself, or do you feel like you need the help of somebody else in order to meet these needs? So as you move forward in operating your business, you really need to think about what your goals are and then keep those in mind. This is especially important as you try to negotiate any kind of business transaction, whether that's you're hiring somebody and you're trying to negotiate what their salary is and what their employment terms are going to be, or if you're competing, if you're negotiating a contract with a supplier of yours or a customer of yours, you really need to keep in mind what your goals are. If you don't know what your goals are, you're going to have a really hard time getting a contract that will help you to meet those goals. So as you start to negotiate contracts and try to move forward with your business, here are some things that you might want to keep in mind. You know, what's the price that you're going to be paying? Or if it's an employment agreement, what's the salary that you're asking for or that you're willing to pay to an employee? What are the terms, the payment terms? Is someone going to pay all of that right up front? Are they going to pay it over time? Is there going to be interest associated with that? You know, what are the terms on which those payments are going to be made? You need to be thinking about non-competes. Sometimes, even in business transactions, you might have a non-compete where if you're going to have access to someone's customers, because maybe you're supplying some sort of product or service, but you're not supplying it to your customer, you're supplying it to their customer or their contacts, they may say, we don't want you going after them directly. So you may have non-compete agreements. You know, we often think about those in the employment context, but you may have a non-compete agreement in some other kinds of contexts as well. It just really depends on what kind of a contract you're negotiating here. You need to think about what's the length of the deal. How long is this relationship going to be in play? Is it just for the period of this one particular project that you're working on, or is this going to be a longer term project? Are you giving people favorable pricing because they're agreeing to purchase from you over long periods of time? Or is this just a one-off deal? They're buying one set of products from you or one set of services from you. And so it's not going to be repeat business. So you have a very short term on your contract. You need to be thinking about what kind of financing you might have. Or are you going to extend financing to somebody else? If your customers can't pay for everything up front, are you willing to carry that account receivable from them in order to get that transaction? And if so, how do you know when that is going to come due? And what are the terms on which you can call them in default if they haven't made a payment? If they do go into default, what are the default provisions? Are you going to charge them extra interest? Are you going to charge them penalties? Do you have the ability to foreclose against some sort of security that they've offered to you? You know, what are default provisions just in case somebody doesn't fulfill their obligations under the agreement? And then the last one I've got here, and this is by no means an exhaustive list, but another thing you might think about are what kinds of representations and warranties are you going to give? If you're installing product, can you warrant that product is good, or do you need to assign a warranty that you received when you purchased the product? Are you going to assign that warranty over to somebody else? Can you make representations about whether you have licenses or whether you have certain certifications? And what are the repercussions if you do not have those licenses or you do not have those certifications? Is it something that you're able to move forward with? Can you make these representations and warranties in your agreement? So once you know what these goals are, once you've thought through all of the different things that are important to you, you really need to rank those in some order of importance. And in our office, we like to call these boulders, gravel, and sand. So the boulders would be the big ticket items, really deal breaker terms that you have to have as part of your deal, or you're just not going to move forward. You may have certain boulders. The person you're negotiating with may have their own boulders. They may have their own things that they're very concerned about and want to make sure that they get into any deal that they do. And so you may need to have a conversation and think really hard, to yourself and to the people you're working with. What are these things that are so important that I'm willing to walk away from the deal? Those are the boulders. The gravel are the smaller things that are important to you, but maybe you have some wiggle room there. Maybe the length of the contract is negotiable in your mind, but the price is not. Maybe there's a particular price and you have to hit that price. If you want to give them a longer time to make payments or a longer term, you're willing to do business with them instead of just for 1 month, but for 6 months. Those are things that are important and you should negotiate and be willing to, or think about how you may be willing to negotiate those things, but they may not be deal breakers. And then the sand are the small things that every deal should have, but they're usually things that don't get negotiated. A good example of this might be a venue provision. If you're doing business, if your office is here in DuPage County and you're doing business with someone in Will or Kankakee or Cook, does the contract say where they have to file a lawsuit if there is a dispute, where the parties get to file a lawsuit or have to file a lawsuit if there's a dispute? That's usually not something that is heavily negotiated, but every contract should have a term like that. So the sand are sort of the little tiny things that you really don't think about a lot, but it's really important to have those things, because if something goes south, you want to know where all of those things are in the contract, so that because they're really going to be important in helping you to make sure that you can enforce your rights or protect your rights, depending on what side of the transaction you're on. All right, so when you get around to negotiating a business deal, things that you need to think about, this is sort of the anatomy of a business deal. And a lot of this, you can think about it, if any of you have ever purchased a home, it's very similar to that. You know, you go in and purchase a home, you look at it, you kind of check out the house, you do a quick inspection, you walk through it with your realtor, and then you make an offer. And you may negotiate back and forth a little bit on what the terms of your agreement are going to be. Then you sign a contract. Maybe the contract goes to an attorney who tweaks it a little bit. Maybe you hire an inspector who comes in and checks out the pipes and checks out the water pressure and looks at the roof and all the other things like that. And then you get to a closing date where everybody signs off on the mortgage, signs off on the deed, and the money is transferred. Okay, that's sort of how that structure is the same kind of structure that we often see in any kind of business transaction. So the first thing you might do is negotiate a letter of intent or a term sheet. Why would you want to put some effort into a letter of intent or a term sheet? Well, the short answer is it really gives you a good roadmap as to where the transaction is going to go. If my client comes into me and says, hey, I have this deal, I want to purchase a business, or I want to purchase a bunch of equipment, or maybe I have a lease that I've been negotiating, can you write the contract for me? If I don't have a term sheet from them, there are a lot of terms. Remember the gravel, the sand, stuff like that. There are a lot of terms that I'm not going to know because my client and the other party haven't taken the time yet to get those ideas on paper. So it's really important to get those ideas down on paper, put together a term sheet that everybody signs off on. A term sheet is generally not binding. So you have the ability to back out, but at least everyone knows what the roadmap is for preparing the actual deal document, drafting the agreement, which is the second step here. The second step would be to make sure the contract that you get drafted actually does what your letter of intent said. You know, if you guys have reached an understanding, maybe not a full-blown contract, but you've reached an understanding about what you think the transaction is going to be, then that's what your term sheet is, and then your attorney can use that to draft the agreement. Now, you may spend a little bit of money on an attorney helping you put together a term sheet, but I can promise you're going to spend way less money on the back end if you have a good term sheet, because it's way easier to draft an agreement if you have a good roadmap, a good listing of what those big ticket items are, so that the attorney knows what kinds of provisions to include in the agreement and what kinds of provisions not to include. Now, once you've got the deal, the contract drafted and signed, you usually have a period of some sort of due diligence or some kind of a wait period between signing and closing. And during that wait period between signing and closing, you may perform some due diligence, just like you might hire a home inspector to come in and look at the house that you're going to purchase. Or if you're buying a used car, you might take it to a mechanic to take a look at. You may want to do some due diligence on the company that you're purchasing or the company that you're going to sign this big contract with, because they're going to be a big supplier for you. You may want to check out who their customers are, look at their books, talk to their employees, do other things to know, to make yourself comfortable that this is a company that you want to do business with, or that this is a company that you want to acquire. Because if you don't know those kinds of things, if you haven't had a chance to do that due diligence, you really aren't sure what you're purchasing. And most contracts will give you the ability to perform that due diligence. And if it doesn't, if the person you're doing business with doesn't want you doing any due diligence, that could be a red flag that there's something wrong with the deal here. Remember, we talked about representations and warranties. If they give you a representation about something, but then they won't let you verify that their representation is accurate, that could be a really big red flag that it isn't an accurate representation, and you may not want to do business with these people. So to the extent that you have the ability to do due diligence in your transactions, I would really suggest that you take advantage of that and take the time to try to learn as much as you can about the other side in the business transaction that you're working on. And then finally, you go to closing the deal. Closing generally is a pretty simple transaction. It could be complicated depending on the size of the deal, depending on what else is going on. But often what will happen is you get together, everybody looks to make sure that the money is going to exchange hands correctly. You look at the funds flow memo to make sure that the purchase price is getting distributed the way that everybody expects it to. That all of the professionals are getting paid, that any liens are getting paid off, that the bankers are taking whatever fees they've got. All of those things happen at the closing table, or hopefully happen before the closing table in some sort of a flow chart to show where the money goes. But that's kind of the last step in the transaction, is closing the deal. All right, so just some quick takeaways here before we have some Q&A here at the end. Put some serious thought into what you're doing. You don't want to just jump into a business transaction with both feet. You want to make sure you've thought through well what your strengths and weaknesses are. Remember at the beginning when we were talking about the kinds of things that are your business, the marketing, the HR, the legal, the accounting. You need to understand your limitations so that you have a good sense of what your deal is going to be, and how much work you're going to have to put into this versus hiring somebody else to do that. Make sure that the person who's drafting your documents, whether that's you or your opposing party, your attorney, their attorney, that person has a really good understanding of what this transaction is supposed to be. Give them a really good roadmap in terms of a letter of intent or a term sheet. One of the best takeaways that you can have from this presentation is that make a good record about what you expect your transaction to do, so that when you get the actual document, you can look at it and see if it does what you had anticipated beforehand. Know your limitations. If you're going to try to do things on your own, if you're going to try to do things DIY, whether that's marketing or drafting your own contracts or hiring and firing people all on your own, those are things that you can do. But just know your limitations and know when you need to bring in somebody who has a little more expertise, who has a little more firepower in a particular area, because understanding where to spend your money and where not to spend your money, and where to spend your time and where not to spend your time, is going to be one of the most important things that you do as you put together your business and try to focus on moving forward. And then lastly, get to know all the players on your team and let them know that they can talk to each other. If you have an accountant or a banker or a lawyer, if you have a mentor from the SBDC or some other organization, let them all talk to each other. You'd be surprised how many times I have conversations with my clients' other advisors, and I learn things about the transaction that I didn't know before that change how I think we should be drafting documents, or that change how, if we're in litigation, how we should be moving forward and what kind of litigation position we should be taking. So just know your limitations, know what you want to do, and let your advisors talk to each other, because you might be able to save yourself some time and money. You may spend a little bit of money having them have those conversations, but if they can uncover a problem that you didn't know to ask about because you had some sort of a blind spot, again, getting back to know your limitations, you're going to save yourself a lot of money in the long run. And then the most important takeaway is, this is me. That's my contact information. And these are different kinds of things that we do in our office. My partner, Rick, and I been doing this for a long time, and we're more than happy to meet with you guys. Just feel free to send us an email or give us a call at the phone number there on the screen. We'd be happy to help you out.
Wonderful. Thank you, Charles. And please go ahead. We're gonna promote everybody to be able to speak and join our conversation. Everyone can start, asking questions that you have. But I had my own business for 25 years, and having a good contract and having the right lawyers and business insurance and have the lawyer review your business insurance. Some of these things are crucial and it's very important. I learned a lot of lessons from people, trying to sue you for any kinds of reason. So yes, please join us and start asking questions. Could be anything from startup all the way to your current business. So Mr. Jumeirah, welcome. So you have any questions or take that you like to share or ask?
Sure. Hey, Charles, thank you very much for your presentation today. And I think it's really important for most entrepreneurs to appreciate the value of having a good lawyer. But we do deal with a lot of entrepreneurs, and these would even be guys with MBAs. They try to cut corners from not having a good accountant, not having a good lawyer, not having good insurance. So I just want to give you an opportunity to kind of just share from a high level, maybe even from a war story. What is an example of a deal where it was so obvious that the other side of a startup deal went poorly because they were poorly represented? I guess what I'm looking for is an example that really demonstrate why sometimes it's really, really good and important to not just do LegalZoom or Google or YouTube. No, hire a proper lawyer. I'm asking if you could share a story with everyone here.
Sure. So, I'll give you an example of a situation where I had a client come into our office. She had purchased a restaurant. She purchased it a few years prior. Didn't have any help from an attorney, just did it by herself. It was I believe it was a stock deal. So I don't know if you know the difference between a stock deal and an asset deal. In a stock deal, that's like buying the house, right? An asset deal is like building your own house from scratch and then going in and just buying the furniture and the fixtures and the leftover paint and the carpet, moving things out of the old house into the new house. A stock deal is like going in and just buying the house from scratch, buying the house lock, stock, and barrel, right? You get all the good and all the bad. There are sometimes advantages to doing a stock deal, but generally we like our clients to do asset deals because it tends to be safer. They can kind of cherry pick the assets they like. In this situation, this woman was purchasing this restaurant. She had negotiated it. She had purchased it. She'd been operating for a couple of years, and it was in a pretty good location. It was on a main road. It was right next to it was part of a strip mall. There was a big anchor tenant that was there. And their store was actually right next to the anchor tenant. So you'd think it was a great location because there'd be a lot of foot traffic right next to that anchor tenant. Well, because she had purchased the business, she got the lease that the prior owner had already negotiated, right? She was fulfilling the end of the lease of the person whose business she purchased. So she didn't get to negotiate her own deal because she just went into it with whatever lease they handed to her. Well, after she'd been there for 2 or 3 years, she comes into my office and says, "Hey, I got this letter from the landlord, and they say that they want to, they're going to shut us down. They're going to close up our space and make us move. And they're giving us, 6 months or so, but we've built a clientele. All of our customers know that this is where we're at, and they know that this is where our restaurant is, and they come to see us here. And we really don't want to move. Can you help me understand what's going on here?" Well, she thought she had a really good location because she was right next to this anchor tenant. The problem was there's a provision in the lease that said, "Hey, we have this anchor tenant that's really a lot bigger than you are, and we want to keep them happy because they pay us a lot more rent than you do. And so if they want to expand and take more space, we can kick you out if the person we're going to put in there is this anchor tenant, if they're going to expand into your space. And because she had done this all on her own and hadn't had anybody look at the lease for her before she purchased the restaurant, she had put all of this time and effort into building up a clientele only to have to pack up and move 2 or 3 miles down the road, which you would think 2 or 3 miles, not that big a deal. But if most of your clientele is in the town where you're located, it is a really big deal, because now you're asking them to drive out of town to come find you someplace else. And really you have to pick up a whole new clientele, a whole new set of people, or hope that the people that you have will follow you down the road. Now, would she have chosen not to buy the restaurant if she'd asked me to review the lease ahead of time? Maybe, but she may have read the lease and decided it was still worth it to do that purchase, but she didn't even know that that was in the lease because she hadn't asked anybody to take a look at it when she purchased the business. So, you need to be careful about, knowing your limitations and knowing when you might be stepping into a bear trap like that. At least if she'd had an attorney look at it, she may have known that that provision was there, so she wasn't blindsided when she came. Or maybe she would have asked the seller, look, I'll buy it, but I got to buy it at a discount because there's a possibility, under the provisions of the lease here, there's a possibility that we could get kicked out. If we were 2 doors down and there were 2 or 3 units between us and the anchor tenant, not as big a deal, because then there's 2 or 3 other people who have to get gobbled up first before they come and gobble up our space. But she was right next door to the anchor tenant. What she thought was a great location turned out to be, it was great for the 3 years that she was there, but then it turned out to be not so great because that was exactly the space that the anchor tenant wanted to kick her out and make her move down the road.
So sadly, it sounds like she lost her lease.
Say that again?
It sounds like she lost her lease, unfortunately.
She did, yeah. The landlord
Sure.
had the rights to terminate her lease
Right.
and make her move.
So I guess what I'm getting at, to be fair, and I think most people need to understand this, different lawyers have different expertise. Now, do you feel that any business lawyer would have caught this, or do you feel really someone like you guys are more expert at identifying this weakness in the deal?
I certainly could have caught it. Part of the problem is that the lease that she took over was like a 30 or 40 page lease. And my guess is that if she had come to us and said, hey, can you review this lease? I would have gone through it and I might have flagged it as a potential issue. But unless she had on her radar screen that this was something that was going to be an issue, she may not have put a lot of emphasis on that, right?
Sure. So to put numbers to value, a 40-page lease seems to me that'd be like a 3-hour analysis, wouldn't it?
Yeah,
Okay. So maybe, yeah. So your rate is, I guess the big takeaway, because there's so many questions coming up, to respectfully, Charles. So the big takeaway is 3 hours of an hourly rate. In Chicago, that's about $3.50 an hour. Depends. Some are $5.50, some are less. But that, let's say, $1,000 investment was probably worth $50,000 to $100,000 worth of revenue. And I think that's the big thing to take away as entrepreneurs and business owners. Say, hey, yeah, the reason lawyers are expensive because they've gone through law school, they have the experience, and they have ways of saving you money. And I think that's a big takeaway I wanted to share. So on the flip side, again, it sounds like you have this leasing expertise, especially in a mall. If a lawyer would not have caught that, would the lawyer have been held accountable for that?
Depends on if the lawyer was asked to look for that, right?
Sure.
It really depends on what the client asked for, because I'll have clients come in and I'll say, look, it's a 40-page lease. What provisions are really important to you? What do you want me to look at? Now, part of my job is helping them notice things that they don't know to ask about, right? But it really depends on what they're looking for and what they've asked me to review. But the lawyer might be on the hook if they don't catch that kind of thing and flag it for the client. It just depends on the scenario.
Sure. So the big thing is, despite being a new business owner, just ask a lot of questions and talk to several lawyers to consider what's the analysis and what's the cost. So the other thing to review, especially for new business owners, is how does retainer work? And in this case, if a new client who's never worked with you before and they say, I have a situation, and let's say they said, I have a 40-page document, I want you to make sure I'm covered. you could price it out. But at what time does someone pay a retainer? You know, 2,500, 5,000 a retainer for a business lawyer such as you.
Right. I mean, in my office, it really depends on the kind of work that I'm going to be doing. If I know that it's going to be a bigger project that I'm going to be spending a lot of time on, I may ask for a few $1,000s worth of retainer. What that means is I'll hang on to that money. I put it into my client trust account. So it remains the client's money, but I'm holding it in my account, like almost like an escrow. And then at the end of the month, I'll send out an invoice, and then I will bill against that retainer, and I'll ask the client to pay the invoice, which will replenish the retainer. Okay, so it's called a replenishing retainer agreement. If the client comes in and, you know, I often have clients call me up and say, hey, can you look at this non-compete agreement for me? How much will it cost? I'll take a look at it. I'll read it, you know, spend it half an hour, 45 minutes talking to them about it. And then I'll invoice them after for just an hour of my time. In that case, I usually don't ask for a retainer, but it really depends on the size of the project and how much work I think I'm going to have to put into it. If it's a significant amount of work, I want to have some security that I'm going to get paid. And so I'll usually ask for a retainer up front. If it's just a smaller half an hour, 1 hour project, I probably won't ask for a retainer up front. I'll just send them an invoice at the end and, you know, really cross my fingers that they're actually going to pay it.
So once you receive payment or you get retainer, then as you mentioned at the beginning, just because they're attending today doesn't give you a lawyer-client privilege. But once they pay you, you do have that lawyer-client privilege for them to confidentially handle any situation that they need reviewed. Is that right?
Yeah, I mean, I can handle. I'll do whatever they ask me to if it's within my area of expertise, right? If it's where I feel comfortable.
And then normally for new clients, is it a 15-minute or half-hour free review? I mean, you know, I think a lot of people don't necessarily understand or they're afraid, hey, I need to talk to a lawyer, but I got to pay him for his time. How does it normally work, or what's your recommendation for people to consider when they're
right? So usually I don't charge for about the first half an hour. If someone calls me, I'll usually give them, you know, between 15 minutes and a half an hour free, just to wrap my head around what their scenario is, to get a sense of what the problem is and what kind of issues they have. And then I'll give them an estimate about what I think it might cost, how much time it might take. Always with the caveat that, especially if there's another side involved, how much time I spend is really dependent on how much time, who's on the other side of the table, and whether they're going to be poking holes in what I do or whether I have to review what they've done. Those are the kinds of things that can change how much a project will be, the cost of a project will be. But I'll usually give them 15, 20 minutes just to kind of get a sense of where they're at, give them a sense of what I think the answer might be to their question, with the caveat that I have to, you know, go back and double check it and confirm it. Oftentimes I'm giving them an answer without having seen their documents. So I'll say, well, I have to see the document for sure, but if it says what you've described, I would say X, Y, and Z, right? Okay. And so I'll usually do that for free. And then I'll often put it on my invoice as, you know, the first call for an hour, and then I'll discount it, you know, 50% or something for that first hour to give them a free half an hour. It just kind of depends on what they're looking for and how much time we spend kind of getting the relationship up off the ground. Okay, great, Charles. Thank you. Thank you very much. Now these are questions that we got from the Q&A. We have from Ms. Monica Schneider. I didn't start my business yet I'm wondering if these points you said should be in the operating agreement in an LLC company, or the operating agreement should be something more simple. So if it's a sole member LLC, meaning that there's only one owner, you can have a very simple operating agreement. An operating agreement is like the constitution for the company. It describes how the company is going to operate. For an LLC, that's called an operating agreement. For a corporation, it's called the bylaws. And sometimes you'll have a shareholder agreement if you have multiple shareholders. The fewer owners you have, well, let me say it this way. If you have one owner, it can be very, very simple because you're the only one that you have to deal with, right? But if you have multiple owners, then you're going to start to get more complicated. You have to start thinking about buy-sell provisions, non-compete provisions, who's going to be in control? Is it going to be 50-50 ownership? What do you do if you deadlock? There's lots and lots of things that excuse me, that you have to start to think about it as soon as you have another owner in the mix. And if you start to get 2, 3, 4 owners, multiple owners, you're going to get even more complicated. As long as everybody's on the same page and everybody's happy, you really don't need the complicated deal. The problem is it's never a problem until it's a problem. So better to be thinking about that on the front end so that you don't get into a situation and now you don't have a way to get yourself out of it because you didn't think about it before the problem arose.
I appreciate that, Charles. And I would say as a business advisor and having been in LLCs myself, I would also advise people get their own lawyer to represent their part of the operating agreement. Because to be fair, it's not fair to have one lawyer represent all of your interests because then no one's interests are considered. The other thing too is as you consider LLC versus a corporation, definitely get your accountant involved because there's definitely tax benefits for corporation and LLC and even how it ties in with your personal taxes. Great, Charles. Thank you. We have a next question from Houston Liu. Thank you for your presentation. Number one, do you think it's a good time now to buy a business based on the current economics? And then number two, could you give some idea about the payment methods for hiring a full-time or part-time salesperson? Oh, that's a good question. All right, for number one, do you think it's a good time to buy a business based on the current economic situation we have in the United States?
I mean, I guess it depends on what kind of a business you're getting into, right? And like, it might be, it might not be. I don't know. If you're in the used car business, it's probably a good time to be doing that because used cars are selling like crazy because we've had supply chain issues and they're worth a lot of money because it's just hard to get used cars these days. If you're going to be, if you're a realtor, maybe not so much. Interest rates are going up and housing prices are going up, or they're starting to stagnate. It's just harder to. It just really depends, right? So it's impossible for me to say whether this is a good time to buy or sell a business. It really depends on the market you're in and what your goals are. If you have a lot of opportunity and this is the only time you're going to be able to do it, well, yeah, this is a good time to do it because this is when your opportunity strikes. But I just don't know enough about everybody's situation to generalize that. In terms of payment methods for hiring full-time or part-time salesperson. I'm not sure I quite understand the question, but let me try to answer it as best I can. The salespeople often get paid based on a commission. And so if you have a good commission structure where you have enough of a commission that you can pay to a salesperson for the work that they're going to do for you, and still make a profit, after you've paid them their commission, you're still going to have enough profit left over that you'll turn a profit on the deal, then that might be a good way to pay a salesperson. One of the things you really have to be careful about are the Wage Payment and Collection Act and the different requirements for paying people. A lot of employers think that they could just call everybody an independent contractor and then they can avoid paying taxes and stuff like that. That works until somebody calls the Department of Labor and then you get in trouble because you haven't been paying into unemployment, you haven't been paying minimum wage and overtime. You got to be really careful just calling somebody an independent contractor. Sometimes you can get away with it, but sometimes you can't. But even if they're an employee, there are different ways that you can pay them. And so I guess I would need to know a little bit more about your business and what kind of what your business model is and whether I think that a particular way to pay somebody, whether they're a salesperson or just an office person, it really depends on your situation.
Thanks, Charles. And I would also offer that a good guideline, especially if you have a field sales rep, like someone who's having to knock on doors and leave the office, it's usually the rule of 6. So if you expect them to make $600,000 in sales for you, you should expect to pay them $100,000 total comp. And I speak to that as an executive recruiter. Now, someone who's inside sales, where it's not having to cold call customers and drop in on them, it's a different ratio. But I would regard or recommend a rule of 6 for most full-time sales reps for almost any industry. Okay, great, Charles. And then next question we have from Lucy Grajewski. Thanks, Lucy. Number one, what's the percentage an owner could get from the business as owner, either monthly or yearly? owner is not on payroll. If I could just jump in real quick, Charles, I would recommend, Lucy, if you're an owner, you should get on payroll. One of the guidelines, and you can find this on speaking to most business owners, always pay yourself first because you are an employee, get that unemployment coverage. But I will hand it over to Charles as to what he thinks with kind of deals or situations he's had to deal with getting a business owner drawing or getting paid out at the end of the year.
Right. So, I mean, there's no rule about how much an owner can get paid, whatever percentage it is. I mean, if there's money there and you've paid all of your debts, then you can probably pay yourself. What you can't do, or what you might get in trouble doing, is if you're paying yourself as an owner, not as an employee, but you're paying yourself as an owner out of the profits before you pay your creditors. So if you have creditors that you're not paying, but you're taking profits out of the company, you're going to run into problems. They may come after you for breach of fiduciary duty, for taking money out of the company. So you got to be careful about that. But as long as all of your creditors are getting paid, there's no rule about whether you can take a draw of 10% of the profits or 20% or 100% of the profits. You just need to make sure that you're getting everybody else paid first before the owners take out their share of the profit.
Right. And I would again say, even if you pay yourself a nominal weekly or monthly salary, at least then you're covered. And if it's reasonable, then to any debtor or vendor, it doesn't look like you're overpaying yourself to not pay them. Right. Thanks, Charles. All right, next we have Undra Uphoff. My question is, I understand having a living trust is important, especially when you're a single member LLC and providing for your family. Is there anything else besides having a living trust to protect your family in case of a tragedy happening?
So I don't know what makes being a single member LLC more likely to have a living trust. I mean, I would say anybody could have a living trust. It really doesn't matter whether you're a single member LLC or a multi-member LLC or an S Corp or a C Corp. The two primary reasons I think for having a living trust are: one, you can avoid the probate process, which is the process where your assets have to run through the court system in order to make sure that they get distributed correctly. And two, if you have any restrictions on how you want your assets to be distributed after you've died, you can put restrictions on it if it is if you go through a will and it has to go probated or be probated. You can have restrictions on how that money gets distributed. But if those restrictions are going to last a long time, what you're doing is causing your executor to have to go back and report to the court, year after year after year, I'm still holding on to this money because the condition hasn't been satisfied yet. Whereas if it's in a trust, nobody has to report to the court. The trustee just hangs on to the money, waits for that condition to be satisfied, whether it's somebody hits a certain age or they graduate from college or whatever, and then that money can be distributed. So those are the two big reasons I would say having a living trust is to avoid probate, and then to have a vehicle to hold those funds so that somebody can wait until a certain condition has been met. Whether a single member LLC, I don't know that really plays into whether you should have a trust.
One thing I did want to add, having been involved in a family business that was a corporation, but the checking account was under an irrevocable trust, that when you get credit, and this example was simply deciding to get a lease on a copier, there were some extra steps they had to go to get credit because they saw that our checking account was tied to an irrevocable trust. In other words, how would in this case, the copier company be able to recover money if it's going through a trust that then, of course, protects or shadows the business relationship to the paying for that copier. So these are just some things to consider, but I would highly recommend you talk to your lawyer and or accountant as you set up the checking account for your business as a trust. All right, great. Thank you, Charles. Next, I have Belvin Luke. We have a tenant that's been delinquent on their monthly rent since the start of COVID and before COVID. The lease is expired and currently is month to month. They have started to make partial rent payments this year, but not the full amount. how difficult is the eviction process?
So
It's a commercial property, by the way. They own a
Yep.
commercial
So
property.
in a scenario like this, you have to give them, so if somebody isn't paying their rent, in order to evict them, you first have to give them what's called a 5-day notice. The 5-day notice, you have to serve it on them. You can do it by certified mail, or you can personally deliver it to them. You can have a process server deliver it to them, but you have to give them something that says, hey, you're behind on your rent and this is how much you owe. And if you don't pay us in full in the next 5 days, then we're gonna elect to terminate the lease and file an eviction action against you. If they don't make the payment, so say you get that served on them, the 5-day notice, then you have to file the lawsuit. After you filed the lawsuit, you have to send them a summons. So you have to serve them a second time with a second piece of paper, this time a summons that says, come to court on a certain date and explain to the judge why you shouldn't be evicted. If they show up on that day, they may ask for additional time. They may ask for an opportunity to have a lawyer show up. So then you may come back 2, 3, 4 weeks later when the lawyer shows up, and then the lawyer may say, well, we want to have a trial on this. And then the judge sets a trial date, 4 or 5 weeks in the future. So now you started on day 0, you have 5 days for the 5-day notice, then however many 2 or 3 weeks to get them served. Then they ask for additional time to have an attorney show up. Then you have to come back for the trial. Now you get the order of possession. You finally get that. Then you have to take it to the sheriff. And the sheriff has to set a date 4 or 5 weeks in the future for them to show up and actually throw the tenant out. Okay, so best case scenario is you give them the 5-day notice. They say, I don't have the money. I'm just going to leave and not have an eviction on my record. And they're out in 5 days. Okay, worst case scenario, it could be 4, 5, 6 months. It just depends on how long they drag it out and how many roadblocks they try to put in the way for you to get them out. I often tell clients, I mean, it sounds like they were delinquent before COVID started. Then when COVID hit, you had a problem because there was a moratorium on evictions. May not have been a moratorium on commercial ones, but there certainly was on residential. I would say if you're going to be a landlord, you got to keep them on a short leash. The first month that they're late, you send them that 5-day notice, because the worst thing that you can possibly have as a tenant or as a landlord is a tenant who's not paying, because then you're paying for all of the expenses of the building and you're not collecting any revenue. And the longer you let that drag out, the harder it is. They know that you're not going to come after them, that you're not going to go after them. And so they're just going to milk it for as long as they can and stay as long as they possibly can. So I would say if you're going to be a landlord, have a really big reserve to make sure you can pay 3, 4, 5 months of mortgage payments without money coming in from the tenant. And B, as soon as they fall behind, you send out that notice and make sure that they know that you're going to throw them out if they don't pay up, because that's how you train them to pay their rent every single month.
Yeah, and I would also offer, Belvin, that the judges try to be as objective as possible. So the better your documentation, really, to Charles' point, if you're on point by day 5, you have that notice and you have it documented. They've been served, it's been documented. So a judge can never say, well, you weren't as aggressive at the beginning, and now you're, whatever, you're taking proper procedures. Maybe the tenant is right, and then it could get drawn out. So Charles's advice is spot on, and really it's important to get your tenants to be in tune that, hey, you got to be on point or they're out. Thank you for that, Charles. I do have a follow-up question from Lucy. She's the one who asked the question about a percentage ownership as a business owner, monthly or yearly pay. Her question is the money taxable in the business side or added on personal income?
So the tax question, I'd say go talk to your accountant. But I will say that it depends on how your corporation's formed. If it is
this is an LLC.
Okay, so if we're talking an LLC, then you can still, the LLC, generally what happens is the owners will get something called a K1, and the K1 will show how much of the profit they have received. The LLC won't pay any taxes on that, but the individual will pay taxes because that K1 will show up on their 1040, on their individual 1040. I can't remember. I think in Illinois, an LLC pays a recapture tax. So there's a little bit of tax that the LLC does pay to the state, but the LLC is not going to pay any amounts to the feds as long as it's a pass-through entity. the LLC could elect to be taxed as a corporation, as a C corporation, and then it would, the corporation, the LLC would then pay tax on the profits that it earns. And then if it makes a distribution to the owners, then the owners would also pay tax on top of that. But that's a rarity. I almost never see LLCs that elect to be taxed as a C corp. It's not uncommon to see an LLC elect to be taxed as an S corp, which is also pass-through entity. And again, you might pay some amounts of recapture tax to the state of Illinois. You're probably not paying any tax to the feds, but then you're paying it. All of that's going to show up on your tax return as income on your tax return. It may get taxed as self-employment tax, which means that you're paying the employer side taxes as well as the employee side taxes when that hits your tax return. However, if you've elected to be taxed as an S corporation, you probably aren't going to pay that, but then the IRS is going to require that you have some sort of reasonable income so that they can get the tax out of your payroll, right? They're going to require that you pay yourself some payroll. So I would say on any kind of tax question, go talk to an accountant, but that's generally how it works out. But it's really going to be specific to your situation.
All right, thanks, Charles. All right, we're going to have to turn on the 30-second clock, Charles. We just have a few more questions. I'm going to let, of course, Cheda close us out. So 30 seconds for these really good questions are coming up here. All right, we have Undra. What should you include when you look for purchasing business insurance? 30 seconds.
I mean, I would get yourself a good broker and explain to the broker what your business is, and they'll be able to help you understand what kind of coverage you should get. But really, your broker needs to know what kind of business you have, and they'll be able to help you understand what kind of coverage to get.
Great. Kimberly's asking, when do I need a lawyer to get a trademark?
So you have as soon as you start using a logo, you have a trademark. So you can see up here in the corner here, this LW next to my head. That's a mark that we have. We've not registered that, but that is a mark that has some protection. It only has protection where we're actually using it and marketing it. So you don't have to register a trademark with the trademark office in order to have protection, but you'll have more protection if you register it. You don't need a lawyer to register it. You can do it yourself, but you know, there's a lot of steps to jump through or hoops to jump through in order to get that registered. So you may want to have an attorney who can help you out with it.
Yeah, our experience is about $1,500 to $2,000 to do a proper trademark. It's a heads up for everyone. All right, next we have Ms. Parinda Setia. Do you offer a sales agreement service, and how much in general is it?
Depends on the sales agreement, how many bells and whistles you want in the agreement. But yeah, we can help you put together a sales agreement. Again, I'd want to see some kind of a term sheet. What is important to you to go into the agreement? And once I know what is important to you, I can give you a better sense of how long it's going to take me to do it, what the cost might be.
All right, thanks. And then, we have a thank you from Maria. She thanks you for the presentation and especially the information about the contracts. And then a final question here from Belvin Luke. My mother has a trust set up after my father had passed away in the early 2000s. However, I can't seem to find a signed copy of the trust. I tried to reach out to the lawyer who set up the trust, but I can't seem to find him anymore. How do I know if the trust is registered?
You don't register a trust. There's no place that it would be registered. I guess I would want to know. You
could do that with the county, couldn't you? Like Cook County?
There's not a registry where you send trusts when they get executed. Everybody just hangs on to that personally. When someone dies, you have to file the will with the clerk of the circuit court, but that's after the person's died. And so even if they're alive, there's no registry where you send things like this. So if you can't find an executed copy of it, I would want to know what kinds of document or what kinds of assets are in the trust and who is trying to take them out of the trust. And then we can try to figure out whether, if you have an unexecuted copy of the trust, we can take a look at that and see if we can get people to who will be willing to accept it, or maybe we have to go to court and get the courts to issue an order saying that that unexecuted trust is something that we can rely on. But give me a call if you want me to help you work through that. Either I can help you with it or I can help you find somebody who does that.
All right, Charles, this has been great. Cheda, I hand it off to you, sir.
Thank you. Thank you, Charles, and thank you, Edgar, for coordinating. Just so everybody knows, we have a free session like this for CPA, and we're going to have another free sessions for attorneys again. So hopefully Charles can join us again. So please be on the lookout for our newsletters. If you are our current SBDC clients, we will be doing more of these, especially the month of September. So please, let us know also, because we do have abilities to set a one-on-one meetings for our SBDC clients. So please reach out to us. My administrative Tommy, so he will be sending our record videos of this and our contact informations again to everybody who register. So thank you again for Charles Wentworth and everyone for these great webinars, and please reach out to us anytime we can help you with all the questions that you had. And once it needed, CPA or attorneys, we will recommend the proper ones for you. Thank you so much, everybody, and have a wonderful day.
Thanks, everyone. Thanks again, Charles. It's been great.